My name is Jim Gilbert, and I'm the Director of Executive Education at Berkeley Law. And I want to welcome you to part 3 of our Whistleblower webinar series. Today, we are going to be joined by Jamie Yavelberg, Chris Ehrman, and Sean McKessy, and our moderator, as it was in the first webinar, first part of our series, is Erika Kelton. As we've done in the past, for those of you who would like MCLE credit for this webinar, please be sure to fill out the online form that you'll find at the URL on the screen, tinyurl.com/bb-whistleblower3. You'll also find that link in the chat. That link will be there throughout the webinar. So please, at some point, make sure that you either click on it now to open up a window or just make sure to copy that so that you can complete that form. And at the conclusion of the webinar, we will send out a certificate of attendance to everyone who fills out the form. I know that many of you have been joining us for all 3 of these, and you've heard me talk about some of our upcoming programs. So I really just want to focus on one new program that I haven't mentioned in the past, and that is VC University Online. This program enables participants to learn the nuts and bolts of venture finance and earn a certificate of completion. The course components include lectures, conversations with leading venture capitalists, interactivities, and networking. The course opened June 1st, but registration is now open. I invite you to visit executive.law.berkeley.edu to learn about that program and the other programs that are here listed on the screen. And I also particularly want to point out our upcoming Berkeley Boost that will take place this Wednesday. Its focus is women in law, policy, and government. There's still space in that. You can register for that webinar for free at the URL on the screen, executive.law.berkeley.edu. So that brings us to today, session 3 of our Whistleblower series. Today's topic will focus on, we're going to have officials from the Department of Justice, Securities and Exchange Commission, and the Commodity Futures Trading Commission discussing the successes and impacts of their agency's whistleblower programs and what lies ahead for whistleblower enforcement in the near and longer terms. Our moderator today, as I mentioned, is Erika Kelton. Erika is a partner at Phillips Cohen, an internationally recognized whistleblower lawyer and a Berkeley Law alum. So with that, I'll turn it over to Erika and she'll introduce our speakers.
Thank you, Jim, and thank you all for joining us today for the last session in our Speaking Up series on whistleblowers and whistleblower approaches to fraud enforcement. During the last 2 sessions, we heard from individuals who spoke up when they saw wrongdoing. And last week, we were also spent time with experts learning about the history of the Federal False Claims Act and this innovative structure that gives whistleblowers a unique position in civil fraud enforcement. Today, we'll look at the impacts whistleblower laws have had, both in terms of combating frauds against the federal government, as well as frauds in our financial markets. I'm joined by Jamie Yavelberg, Chris Ehrman, and Sean McKessy, all in Washington, D.C. Jamie Yavelberg is the director of the U.S. Justice Department Civil Division Fraud Section. This is a section that handles False Claims Act cases, the majority of which are now initiated by whistleblowers. Jamie has spent the majority of her career in civil frauds, and there are few people with her depth of experience and insight. Chris Ehrman has been the director of the CFTC's Whistleblower Office since 2013. Under Chris's leadership, the CFTC Whistleblower Program has undergone significant growth. I want to note that his program reached an important milestone on Friday when it was announced that CFTC whistleblower matters have led to over $1 billion in monetary sanctions by the CFTC. Congratulations, Chris, and welcome. And Sean McKessy is a partner at Phillips Cohen in Washington, D.C., as I mentioned, representing whistleblowers. He was the first chief of the SEC's Whistleblower Office and built the SEC's whistleblower program from the ground up. And he was very instrumental in its successes. Thank you all for being here. I want to provide a little bit of background about the SEC and CFTC whistleblower programs because there are some important differences. Those programs were created in the wake of the 2008 financial crisis and the Bernie Madoff scandal. As we discussed a little bit in our very first session, the SEC had ignored 6 different people who had sounded alarms about Madoff's Ponzi scheme. Congress responded to this by establishing whistleblower programs at both the SEC and the CFTC. Those programs are similar to the False Claims Act in that they all offer financial incentives for information from individuals. But there are important differences between the FCA's key TAM provisions and the SEC and CFTC programs. The biggest is that the SEC and CFTC programs do not have a true key TAM mechanism. SEC and CFTC whistleblowers make a written submission of their allegations to those agencies, but they don't have standing to file a complaint in federal court like whistleblowers under the False Claims Act. In addition, if the agency does not pursue the allegations, the whistleblower has no right to pursue them on their own. Another really important difference because, of course, under the key TAM provisions of the False Claims Act, in most cases, or in many cases, the whistleblower is entitled to pursue those allegations on his or her own. Okay, with those distinctions in mind, let's get started. I'd like each of you to start by taking a look back at your respective whistleblower programs. Jamie, starting with you, it's been 35 years remarkably since the False Claims Act's key TAM provisions, whistleblower provisions, were reinvigorated with the 1986 False Claims Act amendments. That's a long history. What stands out to you in terms of impacts and successes?
So thank you, Erika. I thank you and to the organizers of the Berkeley Law Executive Education Conference and panel. I'm delighted to be here today with my fellow panelists. As Erika mentioned, I'm the director of the Civil Fraud section at the Justice Department, and I have been at the department for many years. And my career, as Erika noted, has been in this space involving False Claims Act cases and dealing with whistleblowers on those matters. So I think, Erika, just to give kind of a couple of highlights, and I know that most of the folks probably have joined the prior conferences that you had, but as you know, the whistleblower provisions of the False Claims Act were originally enacted in light of rampant fraud during the Civil War, when the government was contracting for sugar and got sand, and contracting for leather and got brown paper. So it has a deep, rich history. The statute, as Erika noted, fast forward to 1986, is really the birth of the now modern whistleblower provisions in the False Claims Act. And what they do is incentivize whistleblowers to report fraud to the government by giving them a share of the recovery if the case ultimately is successful. I think in the history of the False Claims Act, what we have seen is that these provisions attract all kinds of whistleblowers. We get whistleblowers who are high up in the company, whistleblowers who are insiders who really were very involved and knowledgeable. There are sometimes whistleblowers who actually were involved in some of the misconduct. And then there are whistleblowers who hear about something who may not have necessarily been sort of a unique insider, but still have information to share and conscientiously bring it to the government's attention, in part incentivized by the fact that there are these rewards for whistleblowers under the statute. So I think we've seen a variety of the kinds of whistleblowers, all of which contribute in different ways to the statute. I think what we've also seen is that the statute clearly creates a partnership between the citizenry and the federal government in rooting out fraud. These provisions have really become essential to our enforcement mechanism and our enforcement actions at the Justice Department. And we have seen this partnership really grow and flourish under these provisions. And just to give some statistics, which may or may not have been shared on prior panels, but since 1986, the federal government has recovered over $64 billion in False Claims Act cases. And out of that number, about 3/4 of that is attributable to cases that have been brought by whistleblowers. So it's very sizable and really demonstrates the value of this partnership. During that time, those whistleblowers have been awarded over $7 billion under the statute. So over that long period of time, the 35 years of history, whistleblowers have earned those shares over that very long period of time. We've also had over 14,000 cases under these whistleblower provisions, and we get about 600 to 700 cases per year filed under these. So it's really a very robust mechanism that alerts the government to this potential fraud. Erika, I could also, I could pause now, or I could also note that some of the ways that the statute has assisted, not just in terms of monetary recovery, but in terms of helping the government in other ways. But I could take a breath here and see how you'd like to proceed.
Well, why don't we move on to Chris and Sean, and we can circle back to you, Jamie. That
Sure.
would be great. And thank you for that introduction. I mean, it really is quite staggering when you add up all the numbers, both of cases and the value of the cases and the amounts that have been paid to whistleblowers over the years. So Sean, not quite as long a history, nearly 11 years now, but how about your views on the successes and impacts of the SEC whistleblower program?
Sure, thanks. I was thinking we might have wanted to build this, have Chris go, then me, and then Jamie, to start with, the kind of numbers that Jamie just did. It's going to seem like a step down here, but just to give you a little bit more context, the SEC program was created by Dodd-Frank, the massive statute that was passed in 2010 in the wake of the financial crisis, somewhat in the shadow of Madoff, although as Erika pointed out, many people had already been incentivized to report on Madoff without the program. So there's not a straight line between the program and Madoff necessarily. But the idea was, in light of the financial crisis, some things had to change. And, Congress came up with hundreds of pages of things, one of which was providing the SEC with an additional tool to incentivize people to come forward, which is the whistleblower program, and required someone to be hired to run it. And so I was happy to take advantage of that and get the gig to start. The SEC passed rules in 2011 to give the framework for the program, and then I spent my 5 years or so building it, as you mentioned, Erika, from scratch. 3 major components of it: confidentiality. People at the SEC are required not to directly or indirectly identify people who come to them under the whistleblower program. Anti-retaliation protections. For the first time, the SEC can, and it now has, brought retaliation cases against companies and punished them for retaliating. And then the financial incentives. And the idea behind it was not to necessarily pay people, although that was, a clear motivation, but to incentivize people to come forward. And how is the program done? In the last fiscal year 2020, 6,900 tips were received by the whistleblower office, by far the most that had been received at all in any prior year. Over 40,200 tips have been received under the program since August of 2011, when the rules went into effect. So it's had the desired impact to incentivize people to come forward. And those people, echoing a lot of what Jamie said, come from all walks of life. Insiders, outsiders, independent analysts, ex-spouses of almost all of the above, disgruntled former employees, disgruntled current employees, and really all walks of life. The SEC whistleblower program covers all violations, and we certainly have seen, both in my practice at the SEC and now in my practice at Phillips Cohen, there is a broad array of kinds of violations being reported on a yearly basis. In terms of the financial incentive, 153 people have now been paid under the program, amounts totaling $816 million. The SEC hasn't updated this stat, but I'm guessing that the amount of monies returned to investors must now exceed $2 billion. As of the end of the last fiscal year, it had exceeded $1 billion. With all the payouts they've made this fiscal quarter, I think it probably exceeds $2 billion, and the entirety of sanctions, I'm guessing, is somewhere in the $10 to $15 billion range. A pretty impressive track record in a relatively short period of time. One last aspect is somewhat tangential to retaliation. The SEC has also brought 12 actions under a provision that prevents companies from not preventing people from reporting to the SEC under 21F17A, which allows them, the SEC, to punish companies that seek to censor people from coming forward. And 12 actions have been brought, and it seems to have had a good deterrent effect.
Great, thank you, Sean. How about you, Chris? How would you sum up the impact and successes of the 10 or 11 years now of the CFTC whistleblower program?
And it seems like a longer time, doesn't it? And before I speak, just to let you know, since I'm a government official, everything I say today is my own personal opinion, does not necessarily reflect the opinions of the commissioners and anyone else at the CFTC. So now the filter is off. Just a quick explanation of the agency. Everything that Sean said, the very important points about this SEC's whistleblower program regarding protections and incentives and all of those apply equally to the CFTC, so I won't go over that again. But just know that the CFTC is a much smaller agency. Its footprint is small, but its impact is significant. We are the primary regulator for derivatives in the US, and that is futures, hence commodity futures, the name of the agency, although commodity futures are very, very important. That's maybe 9 to 10% of what we do. The bulk of the futures now are financial futures. And Dodd-Frank also introduced swaps to the world, and we are the primary regulator for swaps transactions as well. These are all very highly technical hedging financial instruments that allow various people in our marketplace to hedge risk where they feel it's appropriate and for getting price certainty. As far as the successes of the program, I had no idea how much the whistleblower program would drive the Division of Enforcement at the CFTC. When I arrived, I was the second director, and we had a little bit of trouble getting out of the gate, but we've built it up. But we're at a point now where between 30 and 40% of all active investigations at the CFTC involve a whistleblower. And if you had told me that when I started, I would have never believed it. And it is because I think that the leadership in the agency, won't pat myself on the back, but has done a very good job of reaching out to whistleblowers and their counsel, and just we've engaged in a tremendous amount of outreach to let people know about the agency and what we're all about, and our commitment to confidentiality and being professional and doing all that we can to welcome people in and give them as much protection and comfort as we can. I like to think that that's what has happened, but again, that success. And then the number, Erika, you talked about, over 123 million now in monetary sanctions or monies paid to whistleblowers in connection with over $1 billion in monetary sanctions, was a number I did not know we would hit so quickly. So I think it is how quickly we were able to make up the ground we lost initially, and now it's a much more important part of the agency than I ever initially imagined.
Yeah, these statistics are really powerful. I mean, 40% of the enforcement matters brought by the CFTC are generated by whistleblowers, and a full 75% of civil fraud cases under the False Claims Act are initiated by whistleblowers. It really shows the profound impact on civil fraud enforcement generally in the US. At some point, I'd like to get more of the flavor of the kinds of cases and the trends that you all are seeing. But before we turn to that, you know, our first panel talked about the resistance that whistleblowers sometimes encounter when they, or often encounter, honestly, when they speak up within their organizations. And of course, a Madoff example is also testimony to how that resistance can occur within public institutions, like in that case, the SEC. So Sean, I'm curious, you started the SEC's program not long after the Madoff scandal. And I think it would be very interesting if you could talk some about what you did to shift the institutional perceptions and shift the institutional culture around whistleblowing at the SEC.
Sure. And to be clear, I was not one of the 6 that Harry called to report on Madoff. I hadn't rejoined the commission at that point and rejoined to set up the whistleblower office in 2011. And you know, it's an interesting thing. Looking back on, you know, standing up a program, I would say that the Madoff situation, the Inspector General's approach to the Madoff situation, Mr. Markopoulos's testimony before Congress had the staff really shook. I really noted the difference between when I had been an enforcement attorney back in the late 90s and when I rejoined in 2011. And, you know, to say that the whistleblower office and someone called the chief of the whistleblower office was welcomed with open arms by the staff would be vastly overstating it. One of the first things I did actually was hold a council of senior enforcement people, you know, old friends of mine from my prior stint. And, you know, what I heard was everyone is nervous that you're going to come in and second guess what we're doing. You're going to force us to make cases that don't deserve attention. You know, are we going to be forced because the person comes in as a whistleblower to treat them any better? And so I spent a lot of time, you know, kind of level setting. And you know, frankly, enforcement attorneys are human beings as well. And we all have been, I don't know, schooled is the right word, but we've heard these things about, you know, testing people's motives if they're in it for the money. If they're only in it for the money, then, you know, what good are they? And, you know, there was a lot of that kind of resistance. And so I spent a lot of time in my training sessions with the staff, not only going over what they need to do from a confidentiality standpoint, but also to get past this notion that someone who's in it for the money should be not believed or should not be taken seriously. You know, the fact of the matter is that Congress not only said it's okay to be in it for the money, they wanted you to be in it for the money. That's why they created the program with the financial incentive. And so, you know, you talk about marketing the program externally. That certainly was a big part of the job, but selling it internally was certainly something that needed to happen. And it took a while. I think it was erosion more than, you know, conversion. But, you know, I'm proud to say, and now that I'm experiencing it on the other side, I'm really happy with how the enforcement staff is approaching whistleblowers and their counsel, thinking of them as partners, thinking of them as, we'll never get, I think, to the key tam level where it's a true partnership. But I think times have changed. People's reactions to whistleblowers have changed. You know, I get calls from my former colleagues all the time, like, send me some more good whistleblower cases, you know, which was, I think, would have been unheard of, you know, when I first stood up the program. But, you know, I think getting past that, you know, this notion of, you know, if you pay people, somehow it makes the process tainted. You know, at the end of the day, if they're helping bring good cases, and, you know, over $1 billion is now back in the pockets of people who were victimized in the 153 cases, or the 153 people who've been paid under the program, that's the kind of success that rolls. It's like a stone rolling downhill, and has allowed the program, I think, to both internally and externally become very, very credible and very valued. And that's, you know, that if I have, you know, some part of my legacy attached to that, I'm really proud of it.
Yeah, and you have every right to be proud of it. It's important to note too that what you built, Sean, was truly from the ground up. And under the False Claims Act, as Jamie noted, there is a structure of public-private partnership, of collaboration. You know, the whistleblower or relator, or key tam plaintiff, as their term, has certain rights, and it's under the scrutiny of a federal judge. So there's a level of transparency. The Justice Department has deadlines on deciding. The whistleblower has screaming rights to object at various points, and none of that kind of or collaboration is built in to the SEC and CFTC program, other than getting an award if you're successful and providing information. to the
I would add just one other thing, Eric. I would add that both the CFTC and SEC being required to set up an office of the whistleblower, I think is a powerful message that whistleblowers are welcome. And I know Chris, I'm sure shares this sentiment. My job was to be a concierge for whistleblowers and to be an advocate for them. And so, if they were having trouble, you could call me. And on the other hand, if staff was having trouble with troublesome whistleblowers, and let's face it, they're not all the most agreeable people, staff could come to me and say, can you massage this relationship? Can you act as a liaison? And I think that's really powerful. I think having a face and a name to a program and allowing for knowing you could go somewhere and maybe there was not much I could do, but I would do anything I can. And I know Jane was the same way. And Chris, I know, is the same.
Yeah, no, I think that's a really important point. And we've seen with some follow-on whistleblower programs how the lack of an office has weakened the efforts. The NHTSA, the Transportation Authority, the Motor Vehicle Safety Whistleblower Program, has struggled a bit in the absence of a whistleblower office. But Chris, I want to get back to you and what efforts you undertook to shift the culture at the CFTC. And one other thing I'd like you to speak a little bit about, because I think it's quite innovative, is how you will periodically put out public notices or public appeals to potential whistleblowers that you're on the lookout for certain kinds of information.
Absolutely.
Yeah.
I'm sorry to interrupt. My apologies. But
No,
everything
everything
that Sean said applies to us. Change is never easy, and in a government agency, I think that's even more so. And I did a lot of selling on the inside as well. I mean, it was outreach, to the stakeholders within the building and dealing with the same issues that Sean had. The last thing, I wanted people thinking that I was going to be looking over their shoulder or anything else. And I took this page out of Sean's book, was to making abundantly clear that, that is not my role. What you do with the information is entirely up to you. Whistleblower or not, is this the kind of case you want to bring? The program is designed to bring in better data. So if a whistleblower brings in bad data, that's no help. That's not what the program was designed to do. We don't want the tail wagging the dog. And fortunately, the program has worked, and it has incentivized a lot of people to come in that I think we normally wouldn't see. And I think another important point is about independent. We have this concept of original information, was what someone has to provide. And there's two parts to that. One is independent knowledge, which is a fancy way of saying things we don't know about. The other one is independent analysis. And the independent analysis really shows how I think we're a little bit closer to the key TAM than sometimes we get credit for, and that we will bring in whistleblowers or they will come into us who are experts in, let's say, trading. And while we do surveillance, we're not professional traders. So we have people who are watching the marketplace on a daily basis. They can come in and educate us on these are the types of things that I've been seeing that could possibly be spoofing, or someone interacting with the marketplace in a way that disrupts supply and demand or gets between the natural sellers and the natural buyers. We don't know that. So having access to people who can come in and really take us by the hand and act as experts and allow us to get where we need to be is critical, because we're always going to be behind the industry. We try, but the industry is always going to be more innovative. And the other point about the alerts we put out a number of them, and I encourage you all to visit whistleblower.gov, whistleblower, singular, whistleblowers.gov will take you to the OSHA site, which is a fine site, but you won't get much information on the CFTC other than a link that'll take you over there if you want to. So that has the history of the program, rules, statutes, past orders, press releases, all that. But also, as Eric, as you pointed out, we have these investor alerts to the marketplace. And that's a product of the former director, Jamie McDonald, who really cemented the relationship between the office of the whistleblower office and the Division of Enforcement, unifying us and saying, you are such a part of what we do. We want you to be at the forefront, telling people who could be whistleblowers or counsel for whistleblowers, the sort of things that we are interested in as an agency and what is important to us. Be on the lookout. If you see this sort of stuff, tell us. This way, whistleblowers are more educated than Erika, folks like you and Sean, who are lawyers for whistleblowers. When you hear it from people who come in to maybe retain you. And that was a partnership that we had never done before. I mean, Office of the Whistleblower at the SEC and our office are both part of the Division of Enforcement, but we had never seen the Whistleblower Office acting as a mouthpiece for the division. And in doing that, I think that brought folks in a little bit, or gave them a little more comfort that we're part of the process, and we're not some pointy-headed bureaucrat that's going to sort of take your TCR and send you on your way. We are there when you need us, and we are involved, and we understand what the agency's mission is all about.
All right. Just a note for the audience, you use the term TCR, Chris, that refers to tips, complaints, or referrals, and that
Yes.
is the form that whistleblowers for both the SEC and CFTC programs submit their information through. Jamie, back to you. You know, when you think about it, the amount of federal spending that's going on right now is absolutely staggering. We have trillions and trillions that has been, well, both proposed and enacted, appropriated through the CARES Act, the American Rescue Plan, now the infrastructure bill, and there are also efforts ongoing to expand access to healthcare. Can you discuss the importance of False Claims Act whistleblowers in times of massive spending? And are you seeing or expecting a surge in whistleblower cases in response?
Sure, thank you. So Erika, if I could just tack on to a couple of things that Chris and Sean noted about their programs. So one thing to keep in mind is and I think consistent with what Chris and Sean said, is that not every whistleblower complaint turns out to be a viable case. So the independence of the prosecutors that both Sean and Chris alluded to also exists within the Justice Department. And even with the thousands and thousands of cases we see, only about 20% of them actually result in cases that we bring. So we get way many more tips than we ultimately end up proceeding with. But it takes going through that effort and getting all of them in to find the good ones. So we spend a lot of time on matters that either don't bear out or just are incorrectly they're incorrect assumptions by a whistleblower. And then the other point, Erika, if you'll let me, that I wanted to make here is that the cases really aren't just about money, right? I mean, although these are civil matters, and at the end of the day, we recover a lot for the federal government and whistleblowers get a share of it, the cases do achieve a lot of other important goals for the government. They deter conduct, so they prevent others from engaging in similar conduct going forward. But they also protect the health and safety of citizens in a variety of ways, whether it's competition-related issues, fair market issues, like Chris and Sean undoubtedly would talk about. But on federal programs, it's like the health and safety of the elderly, vulnerable populations. We proceed with cases that ensure that their care is not substandard, and we ensure that the military gets what it bargained for when it's purchasing bulletproof vests, or that programs that are designed to aid small businesses actually are going to small businesses instead of somebody taking advantage of it. So I think that the whistleblower provisions fit into this overall construct, not just because it's about money, but because at the end of the day, the government and the public in general benefits really significantly from all of these programs in ways beyond that. And I think that's really important for people to keep in mind, because it isn't just all about money. But to your point about the current enforcement environment in light of a lot of these federal programs coming after the pandemic, I think you're right to note those as an important area that we think is already in the works and likely to be up and coming. The sheer size of these programs, loans and grants, make it an area that the government is very interested in. There have already been a number of criminal cases announced in connection with some of these programs. The government is really very mindful of the balance that needs to be struck in the handling of these programs and the funds. On the one hand, there was really a very pressing need to get the money out quickly to save businesses that were suffering and industries that were hit very hard as a result of the pandemic, to get funds out there to support healthcare providers who were dealing with a real crisis. So the goal was to get the money distributed, and some of the programs were built up in just a matter of weeks. On the other hand, the government was really concerned about fraud from the inception of these programs, making sure the funds went where they were intended and that they were used as they were supposed to be intended. And so the government did put guardrails in place for these programs. There's congressional oversight. There is the Pandemic Response Accountability Committee. There's a special inspector general for pandemic recovery funds. And the agencies that administer these programs are doing their best to stay on top of them and ensure that that the funds were spent appropriately. From a fraud perspective, government loans and government grants is sort of the bread and butter of False Claims Act practice, has been for many, many years. So the kinds of things that we expect to see and that we are seeing are really very consistent with what we see in other circumstances, whether somebody is not eligible on the front end and they apply, they're misusing funds on the back end, they're providing certifications that aren't truthful during the performance or about their status. We also see situations about procurement where the government is purchasing goods and services in aid of the pandemic, and maybe the government contractor is not providing the goods and services that have been promised. You know, it is an environment that has been challenging for a lot of businesses, and the government is very mindful about pursuing cases in the interests of justice. But just because a company or an industry has been struggling, it doesn't give anyone license to make false statements. And so there's really a balance there on ensuring that we're not cramping these very important programs. But by the same token, it's better for everyone if the programs are followed in the way that they were intended, because then the people who followed the rules and did things the right way benefit from the programs, and there's more to go around for them. So I think this is an area where, excuse me, we do expect to see growth continue. These loans are going out over, you know, every couple of months. There has been more money made available to businesses and industry. And a lot of these programs don't require loans to be repaid for quite some time. So these are fairly long-term, couple-year out programs. So I think we expect this to be a robust area. And we think whistleblowers, as usual, will be on the front lines of identifying and reporting these kinds of concerns.
Right. And just in our practice, we're seeing an influx of cases concerning these funds too. You make a really important point, Jamie, about the vetting of these cases. And just from a practice perspective as well, you know, we get inquiries from hundreds, thousands of people, and not all of these inquiries result in complaints or submissions to the SEC or CFTC. I think it's somewhere between 3 and 5% of inquiries result. So vetting is a really important part of the practice, and certainly in terms of enforcement also. And as well, I mean, the point that you make about public concerns beyond just recovering the money is a very important one. So many of these cases touch, as you note, on matters of great significance to public health, to troop safety. And we're also mindful of that as well. And while from a business perspective, we like cases that will keep the doors open, we will also bring cases that we view as important that are protective of individuals. So thank you for that, Jamie. Sean, I want to get back to you about the anti-retaliation provisions and take a little bit of a deeper dive into that. As we noted, each of these statutes has anti-retaliation provisions. And historically, those provisions have been pursued. If there's a retaliation case, they've been pursued by the individual, not by the agency. So, Sean, can you tell us a little bit about the SEC's kind of innovative, creative view of why it should be involved in enforcing the anti-retaliation provisions of the Dodd-Frank Act?
Sure. So in some regards, it was an outgrowth of the statute. Congress specifically put in the Exchange Act the fact that the commission has, or that is a violation of the Exchange Act to retaliate against individuals, and that meant, from the commission standpoint, we now have the authority. We've been given the authority for the first time to take an action against the company that does a wrongful act against someone who raises in good faith wrongdoing. I say that purposely because it doesn't matter, as the SEC has proven, it does not matter whether the person who reported the wrongdoing was right. It matters that they reported in good faith. And in one of the, I think the SEC has now brought 5 or 6 cases under the anti-retaliation provisions. And the most interesting one from my perspective, and the one I was really hoping would come down the pike while I was still there, was an instance where someone raised an issue. A person who was not an accountant questioned whether the accounting processes were appropriate, and the company discharged the person, and it turned out that he was wrong. His analysis of how the accounting should have happened was not correct. Nevertheless, the SEC brought an action, a standalone retaliation action. So there was no action for the SEC to bring based on faulty accounting, because that turned out not to be a problem. And yet the company got fined $500,000 for taking inappropriate action against someone who reported wrongdoing in good faith. There was no reason to believe he was raising it for any other reason than he thought that it ought to be looked into. I think that's a very exciting development. More broadly, Dodd-Frank created, I think, a much more reasonable and expansive, before the Supreme Court changed it, but an expansive view of retaliation protections, understanding that prior regimes, Sarbanes-Oxley, for example, did not go far enough to empower people to come forward. And so did things like provide a private right of action so that an individual wouldn't have to go through the OSHA process and could go right to court, and also expanded some of the protections, 2.5 times back pay as opposed to 1 time back pay, and a longer statute of limitations. All of this, suggests that what Congress intended in 2010 was to make the world much more agreeable for people to report wrongdoing. And when I say the Supreme Court, I'll just quickly go into what happened there. Under the statute, through what I view as a drafting error, the statute defined whistleblower as someone who reports wrongdoing to the commission. Now, my view is that provision is in this section about how somebody can get paid and the process to get paid. Later in the statute, there's retaliation provisions. Unfortunately, in the drafting of such a large bill, nobody thought to say, well, wait a second, for retaliation purposes, shouldn't someone who reports internally be protected? I think that's what everybody intended. And in fact, there was some legislative history to show that the commentary that said, if you're worried about people who report internally not being protected, of course, they will be protected under the statute. All of this, unfortunately, came down to and was challenged by the defense bar and companies who I don't think realized what they were fighting for, even though I told them that they should stop this fight, and escalated all the way to the Supreme Court. And in a case called Digital Realty, a 9-0 decision, they decided that the statute defines whistleblower as someone who reports wrongdoing to the commission, and therefore people who quote unquote only report internally don't get these much more favorable retaliation treatments, which nobody thinks is right. Nobody thinks that was the intention, but the fact of the matter is that's the way the statute reads. So what we're left with, and again, very contrary to corporate defense bar's interest, is that people now have to report to the SEC to get these enhanced protections. And so, Erika, I know you and I, when we're advising clients, we have to have them mindful many people want to report internally, want the company to do the right thing. And we have to make sure that they know that they may be losing out on some very significant protections unless they report to the agency.
Right. One thing, just as a practitioner in this area, and noting what Jamie said earlier about deterrence, the deterrent impact. In this area in particular, I think the SEC's actions against companies that, through their agreements, whether it's a confidentiality agreement or a severance agreement, have provisions that chill or impede whistleblowing. I think that the SEC's enforcement in that space has had tremendous deterrent impact. I mean, we used to see proposed agreements early in the practice when that would routinely have those kinds of provisions in them. And now I don't know if you agree, Sean, it's rare to find that. And this is also, even with respect to international whistleblowers, the reach is really, I think, quite compelling.
Yeah, I do think that the SEC's interpretation of their authority under 21F17A, which is that provision I mentioned earlier, that makes it where the SEC prohibits entities and companies from taking any actions to prevent people from reporting, it has had a great impact. And the fact that they had a flurry of cases, I think 8 or 9 came down in about a month or month and a half span, and now they're only up to quote unquote only up to 12. And I've been inquiring of my former colleagues at the Office of the Whistleblower if this is because they've decided that it's not important. And the answer has been no. It's actually because companies paid attention. And when I talk about an expansive view, we certainly had instances where people put in a severance agreement specific language that said, you agree in taking this money for severance, you will not report to the Office of the Whistleblower at the SEC. That was at one extreme. Maybe more subtle extremes would be very broad confidentiality provisions, which basically left the person to believe that if they shared their information, any information that they found out about at their jobs, that would be a violation of their severance agreement, or that if you want to report something to the government, you can, but you have to inform the general counsel and have the company have first crack, which gets rid of confidentiality and anonymity. So there were a lot of, quote unquote, creative ways that companies, and in some instances, lazy ways because they didn't look at their confidentiality agreements after the new rules went into effect. But then there were some, creative ways to try to subtly prevent people from reporting. And I think the SEC took a very hard stand on this and viewed their powers under this very broadly, and it has sent a really strong message. And I think rather than try to challenge this either through the courts or in an SEC proceeding, companies are just getting themselves in line and putting in appropriate language that at least puts a carve out that nothing in this agreement prevents you from reporting wrongdoing to the SEC without any repercussions.
Yeah, it really was a profound turnaround, and it really shows the deterrent impact of strategic enforcement like that. We're running out of time. We only have about 10 minutes left, and there are a lot of questions in the chat box. But before we turn to questions, I'd like each of you to tell us what your predictions are for the future of your programs. Are there emerging areas, like for the Justice Department? Will pharma continue to play a really large role in your enforcement efforts? What about cybersecurity, as more and more health records are becoming digitalized, and more IT is being offshored? And for Chris and Sean as well, what do you see on the future? Is cryptocurrency, which is kind of in vogue in enforcement, how's that going to shake out between the agencies? So Jamie, why don't we start with you? What if you had your crystal ball, what would you say is in the future?
Sure. So unfortunately, I don't have a crystal ball, so I don't know for sure. But the department has already noted a couple of areas that will remain priorities, and I think where we expect there to be continued sustained effort. Those do include the response to the pandemic. We're talking about $5 trillion in government relief. So there's no question there that if even 1% of that was a result of fraud and abuse, that there is a lot to be done in that space. We will continue to work on elder justice matters, obviously protecting the most vulnerable, ensuring that they get appropriate care. We've had really unfortunate cases involving failure to provide basic services, food, medicine. Those remain really important to us for fairly obvious reasons. As you noted, electronic health records is a really growth. There's been just exponential growth in that space. The department has already pursued some cases involving those kinds of vendors and the way that they interact with physicians and drug companies. And I do think that will be an area that we will continue to work on. Opioids continues to be an epidemic that really ravages the country. And so we have done a lot of work in that area. And I think that we will continue to sustain that too. And to your question about cybersecurity, I think that's very apt. The government procures software and services, and those are really important to maintain to the level of security that was promised in the contract that the government entered into. And so there is an expectation there. I know that the current administration has already flagged that this is an important area and intends to have investment of resources in that space. So I do think that will be an important area in the future.
Great, thank you, Jamie. Chris, what's up on the horizon at the CFTC?
Interesting. Yeah, I wish I had a crystal ball too, but I think the investor, there's that word again, the alerts that we're putting out will inform that a little bit, at least things that we're interested in and things that we suspect there is more going on. But I think the big ones will continue to be spoofing and trading. I think that's just begun. We're just at the tip of the iceberg on that. We're going to continue with that. Crypto, for the moment, we are going to keep seeing anti-fraud cases brought by us, but we don't have the safety and soundness prudential regulations. No one does really at this point. So right now we seem to have created a nice division of labor between us and the SEC. I don't know whether that will continue, but I still know we will get a lot of data concerning those marketplaces, and we are taking an active look while we can to make sure that we can protect them as much as we can, given the limitation of the rules. Swaps will always be big for us. Nothing on the horizon now, but the problem is the marketplace is so large. Whenever something does go wrong, it's a very large amount of money, and it's a threat to the economy. So we have to keep our eyes on that. And then the more, I hate to use the term garden variety frauds, but they are the Ponzi schemes, the metal scams. It's just various people claiming that they're going to give these wonderful returns on these exotic instruments that they purport to sell that don't exist, and they steal people's money. That's an important part because, as Jamie was pointing out, elderly people tend to get caught up in those the most, and they're the most vulnerable because they don't have the ability to get back into the job market and remake the money they lost. So we will continue more of the same, but crypto and swaps are the things that I think will be the most important over the next year.
Great, thank you. And Sean, what are your thoughts about SEC enforcement? And I know, of course, that now that you're in private practice, you can talk a little bit about how you see the Biden administration's priorities for SEC enforcement in particular.
Sure, and I hope I'm not giving away trade secrets to let Jamie and Chris know that when you get to private practice, they actually give you a crystal ball. So I actually have one, and it works really well. I guess, one of the first things I guess I would just want to say is, and I think I speak for Chris on this, these whistleblower programs are here to stay. This is not a passing fad. $816 million is in the pockets of whistleblowers. 40,000 plus people have come forward to report wrongdoing. The enforcement staff has embraced the program. They're bringing really good cases. So, and I think to your point, Erika, I think there may have been some skepticism about whether whistleblowers would continue to be supported under a Republican SEC. I think those concerns have been addressed. I'm humbled to say that when I left after a 5+ year tenure as the head of the office, we had paid out about $88 million. Jane Norberg, my successor, who's my deputy, she just left after 5+ years, and the program was up to $816 million. So exponential growth, and I have no reason to think that now that the whistleblower office is really clicking on all cylinders, that these kinds of results are going to continue, which is good for us, good for business, and I think good for preventing fraud. In terms of enforcement priorities, the SEC has brought some COVID-related cases against companies who fail to disclose or try to mitigate or under-disclose the potential impacts of COVID. I've had a couple of clients approach me with kind of an interesting twist on COVID, where these individuals are reporting to me that the companies that they work at are trying to explain bad performance or projected difficulties coming down the pike and stuffing them all in the COVID box and saying, these were systematic problems. We were under reporting our accounting for years. And now the company's using COVID as a way to kind of disguise that fact. And I think those kinds of cases are going to be brought. As Chris mentioned, cryptocurrency, anything in that space, Bitcoin, wallets, all that is of extreme interest. The SEC set up a separate division to deal with those, and I know we get a lot of people calling us about that, and that group is very excited to hear when we bring a new case. And then, as Chris said, it's the general cases, Ponzi schemes, insider trading, bad disclosures by broker dealers. All of that is going to continue to be at the forefront. I do think, to your point, Erika, I think the SEC under Chairman Clayton made a very marked and a consistent change to the message that this is about retail investors, protecting retail investors. And I think most people thought that was, favoring Wall Street over Main Street. And I think we should, with the appointment of Chairman Gensler and the new enforcement director with a very strong prosecutorial background, which Chairman Clayton did not have, I think we should look forward to a much more robust enforcement division. I know in talking to my former colleagues, the wind is under their wings, so to speak. They're feeling really motivated again. And so I look forward to a pro-enforcement 4 years and with whistleblowers being a key part of it.
Yeah. Well, I note also that Alex O, who's the new director, recently appointed director of enforcement, that she comes out of the Southern District of New York and prosecuted Foreign Corrupt Practice Act cases. So maybe we'll see kind of a renewed effort in that space as well. Well, with 2 minutes left, I apologize to the attendees. I think we have time for one question. And I think that this question can apply to each of the programs. And it's by an anonymous attendee. How can the whistleblower know that they are bringing new information? And in that case, how can they be protected if, for example, they already placed an internal complaint and thus are subject to implicit retaliation? So it's just taking that first section of the question, how can they know that they're bringing new information? That's important for each of these. There's a first to file provision under the False Claims Act. And certainly if another whistleblower has beat you to the punch at the SEC or CFTC, or if on their own the SEC or CFTC have an open investigation, that whistleblower might not be entitled to an award. So how do you know if you're thinking about acting? Jamie, you want to take a first crack at that?
Sure. So I think you often don't. The cases are that we have are sealed. The cases, I think, with the other agencies are confidential. But that's, Erika, where your office comes in. And so whistleblowers that seek out counsel, I think counsel really can help them navigate that question and figure out whether or not it's likely that there might be something else. They can do research and see whether or not the government's active in the space. Are there other cases out there in this area? Has there been a subpoena issued? Has a company publicly reported something? So there are ways to kind of look around so that you can or try to figure those things out. But I think at the end of the day, there's not really a foolproof way of ensuring that you're the first one in the door. I think, Erika, would you agree based on your experience?
Absolutely. And this is a very significant risk in any case, whether it's False Claims Act or SEC or CFTC. And it's something that we do advise prospective whistleblowers and clients about, and they need to be comfortable that they might end up with nothing. And in the case of the False Claims Act, their names might be disclosed publicly at the end of the day without an award. So Sean and Chris, there is a little difference for the SEC and CFTC programs. If a person comes later, you might still be able to get an award. Can you tell us a little bit about that?
I can talk about it. Sure. The problem with not knowing is that both our statutes describe original information, and it has to be original information provided to us voluntarily. And if it's information that we already have, it doesn't meet the definition. That's a problem. But the good news is it's really hard to line two things up exactly right. And we have sort of two ways you can get into the program. One is to initiate an investigation because it caused to open, which is a much lower threshold. If we haven't done anything, you send us some information, we open up, you're pretty good. If we get to the over $1 million, the other one, what you're describing, is the significant contribution. And we've often had several whistleblowers who all collect on an award. The awards are given on one matter. Each whistleblower, if there's 5 of them, they have to figure out how to share between 10 and 30%. But we've had multiple cases where people provided different information to us, but each of them was significantly contributed to the matter that we ultimately brought. So there is a lot of different ways people can provide information, and no one whistleblower comes in who's perfect, who knows everything. So those opportunities are there. But that being said, as you pointed out, the risk is we may be 10 miles down the road and have heard the same story 5 times before when you come in, but there is just simply no way to do it, to figure that out. Everything is confidential. The good news is if you do tell us something that we already know, the likelihood of your identity being revealed in litigation later is pretty much zero, because we would assert a privilege if someone attempted to get information from us. We're not going to put you on the stand if you can't testify to something or if you're not the best witness. So it's more likely than not that we would not disclose your name unless you, but again, that's always the risk. And I'm sure you tell your clients about that all the time, but the chance are if you come in and give us something that's not particularly helpful, no one's going to find out about it, and it's just going to sort of fade off into the distance.
Right. Sean, I'm going to leave you with the last word on this.
Well, just picking up on Jamie's point, I mean, one of the things I think we can do as counsel is to have a sense of what's out there and what's being worked on. In some ways, it'd be easier to make that calculation, that assessment, if there wasn't this ability to significantly contribute to something that's already being investigated. So the fact that I know that a person has come to me about something that I know the SEC is working on, that doesn't end the inquiry for me. I need to understand, can they move the ball forward? And in a practical matter, there's no way for me to know what the SEC already knows or what they've already done. But one practical tip that I have done, I've had clients come to me about something. I'm like, this has to, the SEC has to be all in on this. And I do have the ability to call, let's say in this instance, it was a cyber case. And I called the head of the cyber unit and I said, I've got somebody who's got what I think is really great information about, XYZ entity. And wouldn't you know it, a couple of days later, I got an email from someone saying, I work at the New York office, and if you have any information about XYZ, you should send it our way. And so that was a way for me to, confirm my suspicion that this has to be something the agency is working on, and then direct it to the right folks. But I've also, I've gotten a couple of denials of claims for awards because at the end of the day, and there's no way for me to know this at the time, the commission, the enforcement staff said, everything you told us was great, but we already had it. It was already, in our investigative file. And that's frustrating, but at the same time, you can't know for 100%. And you just hope that what your client is bringing significantly contributes to something that's already in the hopper.
Yeah, absolutely. Well, we're out of time. I apologize to the other attendees who put questions in the chat box. I'm sorry I wasn't able to get to more of them. Thank you, all the panelists, and thank you to the audience as well.
And I want to extend my thanks to Chris, Sean, and Jamie. Thank you for your time on behalf of Berkeley Law. Erika, thank you again for terrific moderation. And we hope to see all of you in the audience again at a future Berkeley Boost webinar. Thanks again, everyone.